Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing an extremely important criminal law case called R and JJ that deals with how communications between the accused and a complainant can be used in a sexual assault trial. In 2018, the federal government passed what are laws that are sometimes referred to as the Ghomeshi laws. These laws limit the ability of an accused person to use records in their possession that contain private information relating to the complainant in a sexual assault, for example, text messages. The law creates a kind of reverse disclosure obligation on the defense. If the defense has in its possession any record in which the complainant has a reasonable expectation of privacy, the defense must bring an application ahead of time to seek permission from the court to use that evidence at trial. It's up to the judge to determine if the evidence can be admitted. Criminal lawyers are concerned that this reverse disclosure requirement will put the accused at a disadvantage, but proponents of the law have argued that it's important to protect the privacy of victims. The question of the constitutionality of this law has now gone to the Supreme Court, where the appeal was argued in October 2021. Here today to discuss the law, the hearing, and what comes next are two criminal lawyer experts. Gerald Chan was counsel for the Criminal Lawyers Association at the Supreme Court, and Gloria Ng represented another intervener, West Coast Leaf. Thank you both so much for joining me today. Now, Mr. Chan, these laws were enacted following the famous acquittal of Jian Ghomeshi, where text messages from complainants were used pretty effectively by the defense. And they're referred to as these Ghomeshi laws. But is there more to it than that? Is that an accurate reflection of why these laws were enacted?
Well, thanks so much for having me, Christine. I think the term Ghomeshi laws is a good example of how a label can take on a life of its own, even when it's not reflective of how the law actually came about. The law actually was not based on or spurred by the Ghomeshi case, but rather a much older case called Shearing from 2002 in the Supreme Court of Canada. And Shearing had nothing to do with text messages or text communication. It was about a diary that had fallen into the possession of the accused in that case. And so the question was, in Shearing, could the accused simply use the diary in cross-examination of the complainant in a sexual assault trial without having to bring a pretrial application, which the accused would have had to do in ordinary course if he didn't have access to the diary already, if he wanted to gain access to it, but it was simply in the complainant's possession. So that was the case that gave rise to the law, to the Bill C-51, which is before the Supreme Court of Canada and JJ, not Ghomeshi.
So, Ms. Ng, I gave a kind of outline of how this law works. Can you give us an example of how it might be used?
Thanks for having me on this program, Christine. So what these laws do is essentially require the accused to bring an application before they can confront the complainant in cross-examination with records. And so you brought up the example of text messages. It could also be emails. And then especially in this day and age with social media, we're talking about Facebook messages,
and what might
Instagram.
be the purpose of bringing that record? Is it to undermine the credibility of the complainant?
That is usually part of it, and really, what usually you'll see at the heart of these applications is that the accused is saying, "I need to be able to have a right to attack what I see are potential inconsistencies, and that these records are my way to do it."
So, Mr. Chan, what might the judge consider when faced with an application like this? How would they determine whether to allow the accused to use these records?
Sure. So there are a number of factors that the law requires the court to consider when deciding whether or not to grant permission to the defense to use these records. That includes the right of the accused to make full answer in defense to the charges that they're facing. That includes society's interest in encouraging the reporting of sexual offenses and society's interest in encouraging the obtaining of treatment by complainants. The obtaining of treatment is a factor that may be more relevant to a case where the defense is trying to access counseling records or treatment records as opposed to text communications. The court will also consider the need to remove discriminatory beliefs and biases from the fact-finding process. And so much will depend on what is the purpose that the defense is articulating for why they need to use these records, whatever the records happen to be, in confronting the complainant on cross-examination.
So it's sort of a fact-based analysis then?
That's right. That's right.
All right. When we come back from this commercial break, I want to ask you both about what happened at the Supreme Court. What is the allegation about why this law is unconstitutional? What's the argument to say that it is constitutional? Because I think you both represented sort of opposite perspectives as interveners at the Supreme Court. We will be right back. Welcome back to Canadian Justice, where we're discussing a case in front of the Supreme Court dealing with laws of evidence in sexual assault cases. Now, Mr. Chan, this case went to the Supreme Court because the constitutionality of this law was being challenged. What are the constitutional concerns, and how does it relate to, for example, the right to silence or other constitutional rights?
Right. So the constitutional concern really comes down to the principle against self-incrimination. That's protected by Section 7 of our Charter of Rights and Freedoms. And the right to silence is a component of that. But essentially, under Canadian criminal law, the way we've always done things is the accused is charged criminally. And because the accused is presumed innocent, the burden is on the Crown. The burden is on the state to prove the accused's guilt beyond a reasonable doubt without the ability to force the accused to participate in that process. And so the accused is entitled to sit back and say to the government, you have to prove your case against me without any help from me. And that means the accused doesn't have to testify at trial. The accused doesn't have to give a statement to the police when they're being investigated. And it also means that the accused does not have to make disclosure of materials in their possession that they intend to use at trial, or reveal the defense strategy, reveal the line of cross-examination that their lawyers may take to confronting certain witnesses that the Crown may call. That's all part and parcel of this broader idea of the principle against self-incrimination. And the rationale for having this is because our law has historically recognized the tremendous power imbalance between the state and the individual. And our law recognizes that related to the presumption of innocence and related to the ability to make full answer in defense is this notion that the individual should not be conscripted, should not be forced to participate in their own prosecution. And so that's at its core what's at issue, we argued in this case, with this law that now requires the accused to make disclosure of the records in their possession before they use it, not just to the court, not just to the Crown, but also to the complainant, also to the essential Crown witness who they would be confronting with these records at trial in the ordinary course. In this procedure that this law has created, the complainant now gets the ability to object to the use of this evidence against them before this evidence is used. And as part of that process to see what the defense strategy will be.
So, Missing, what you were kind of on the other side of this issue with West Coast Leaf. What did your organization argue about the constitutionality of that law?
So West Coast Leaf and WAVA focused on sort of what Mr. Chan just touched on about complainant participation. And so there was a lot of concern that we could see that there was this idea that if the complainant was a part of this process and in having to determine whether or not these records could be used, that was in somehow a decrease in the rights of the accused. And so what we were emphasizing to the Supreme Court was that when you're looking at complainant participation, it means an actual promotion for the search of the truth, because you're preventing impermissible myths and stereotypes about sexual assault from infecting the trial process. And it was also an emphasis on how complainants, specifically those who face multiple inequalities and barriers, people whose backgrounds are often very different from the lawyers and the judges who are in the courtroom, how naturally having their voice heard in the determination of these records, that does not take away from fair trial rights, as opposed to enhancing and making sure that when we have these trials, that we're getting it right in terms of the balancing of everybody's rights.
Now, Missing, we've got about a minute left, but I want to differentiate this law from another type of law our viewers may be familiar with, which are parochial, commonly called rape shield laws. What's the difference between these two types of laws?
And so with the regime we're talking about records, whereas with what's normally called rape shield laws, you're talking about the prior sexual history. So the sexual past of the complainant and whether or not it's permissible to ask questions about that.
And for those that type of evidence, there is a similar procedure. Is that correct? Where you need to bring an application before a judge to admit that evidence?
Exactly. The idea is that before you can delve into those questions about a complainant's past, you have to be able to make sure that you're not asking the judge to tender that evidence with an eye to say that the complainant should be less likely to be believed because she may have a promiscuous past, what some would characterize as a promiscuous past, or that you're in any way advancing something that isn't actually relevant to an issue at the trial. So you have to be able to show that there's a reason why you're delving into this.
Well, I can certainly see the myths and stereotypes at play there. We've got to go to commercial, but we'll be right back. Welcome back to Canadian Justice, where we're discussing a case involving how evidence can be used in sexual assault trials, and a case about this law governing this issue that's recently been at the Supreme Court of Canada. So, Mr. Chan, one of the things I want to put to you is that it's really important that the complainant or victim has privacy protections. And how do we ensure that the privacy of a victim or complainant is protected if the accused wants to use records like these, like, for example, text messages?
Sure. I guess I'd answer that in a couple of ways. I guess the first point would be privacy is absolutely important, particularly for complainants in sexual assault cases. That being said, it's unavoidable to a certain extent that criminal trials, particularly criminal trials into sexual assault allegations, will get into fairly private material. The second point would be what's important is that you have a procedure in place that ensures that if the defense is going to use this material and engages unique privacy concerns, that it is probative for the defense, that it is relevant to making full and answering defense. It's not going to give rise to myths and stereotypes, and there is a particular purpose that the defense can articulate for why it's being used. There was a procedure in place before this law passed that allowed for that to happen. At common law, if the defense wanted to use these records, which raise sensitive privacy issues, at the point of use, the defense could go to the judge without the complainant present so that they weren't tipped off as to what the defense strategy would be. And at that point, ask the judge for judicial permission, and the Crown would have an opportunity to make submissions. And that gets at the core of what the criminal justice process is intended to be. That is a contest between the individual and the state, not so much a private dispute between two separate individuals. So there was a process in place before Bill C-51 passed, and our submission to the Supreme Court of Canada was that process was adequate and was doing its job to ensure that everyone's interests were properly protected.
Ms. Ng, one of the principles of our courts is that the Crown needs to lay out the case that the accused needs to meet, but the defense doesn't need to lay out their case in advance. So can you explain why that principle is so important in the criminal justice system, and your view on whether this law sort of goes against that principle?
So the principle of the right to be able to know what the Crown is alleging against you is important because it's a fundamental justice issue. And it exists because it recognizes that at the core of our system of the importance of the presumption of innocence. And so in order to make meaningful interpretation of that right, the Crown has to give you everything that they're going to use. And as a result, the defense isn't held to that same level of non-disclosure. But the difficulty is that whether or not it actually gets rid of that or erodes that right is that I would say that the regime doesn't go against the principle in such a clear-cut way because, first of all, the defense isn't being forced to do anything. There are other aspects of evidence that do require a notice requirement. It's not that everything doesn't need to be disclosed. There are certain
for
rules
example, the rape shield laws we spoke about in the last segment.
Yes, for example, exactly. And so if the regime is narrow enough in scope such that the complainant's reasonable expectation of privacy is engaged, then this regime comes forward. The accused is also not required to provide the records as part of its application. They only need to describe with enough detail for the judge to understand what the issue is. And I would just end by saying that it also begs the question that if it's a communication record, for example, and the complainant is on the other side of an email or a text message, then what element of surprise is there truly if he or she was on the other side of that communication? And so the danger of things like messages and arguments that the messages are somehow relevant, because if you've accused somebody of sexually assaulting you, why would you still be in contact with them? Why might there still be fond messages exchanged? Is that then it brings in that question of how does a victim act, and what is the proper way for a victim to behave, and that then engages the impermissible myth and stereotype again. And so the regime, I would say that it makes sure that improper notions like that, rooted in records like that, don't end up disrupting the trial process.
Because Ms. Ng, it's not uncommon, as I understand, for victims or complainants to remain in contact with the person who they're making allegations against.
Yes, and specifically, that's what, again, West Coast Leaf and WAVA was emphasizing, that especially when you look at complainants who are, for multiple reasons, in power imbalance relationships, one can envision situations where, for example, a recently immigrated woman who is dependent on her accuser on the person she's accusing to provide her with sustenance. So there are lots of power dynamics at play.
When we come back, we're going to conclude our conversation about this important issue. Welcome back to Canadian Justice, where we're discussing a recent case before the Supreme Court dealing with the admissibility of evidence in sexual assault cases. Mr. Chan, can you paint a picture for our viewers? Give us an example of how the requirement to disclose evidence before trial, a defense obligation to disclose evidence, might make things harder for the defendant. What would that look like?
Sure. And I hope the picture that I'll try to paint really does illustrate that there are two categories. There's the sexual history evidence, which Gloria talked about earlier, and we think it is quite appropriate to have a judicial pre-screening application to deal with that type of evidence because it's especially prone to myths and stereotypes. But then there's the records category, which is what we're talking about here, which could include text messages between the accused and complainant about the very sexual activity in question in the case. And so, for example, say the complainant alleges over the course of her relationship with the accused, which could have spanned several months, that there was a non-consensual sexual activity, that there was a sexual assault. But the statement to the police isn't particularly clear about, was it the entire duration of the relationship, or was it just one or two isolated instances? And the accused has in their possession text communications with the complainant about the sexual activity, the nature of sexual activity that is described in the police statement, that in fact shows that it's quite consensual, that it's described with a degree of consent from both sides. The defense is going to have an interest at trial in first cross-examining the complainant to pin down what exactly are the allegations of sexual assault. When did they happen? Are they during the course of the entire relationship? Were they on isolated dates or times? And then, depending on what the answers are under oath, if the text messages in the accused's possession contradict those answers, then confronting the complainant with those text messages at that time. The problem with making advanced disclosure before the complainant ever testifies is it creates the danger, and that's not to say that all complainants will tailor their evidence, but there's a general danger, a general concern of witnesses in general, not just in sexual assault cases, but witnesses in general tailoring their evidence to the documents that they know in advance they will be confronted with. And so that's the concern that I think arises from this type of reverse disclosure requirement in all cases, but it's in the sexual assault context that this law has created this requirement.
Good example, Gerald. Ms. Ng, I want to ask you about sort of mission creep of this type of procedure. It started with the rape shield laws, this reverse onus disclosure application, where it involves prior sexual history. Now it's been applied to records. Should we have any concern that it could be applied to other types of evidence, even evidence outside the sexual assault scenario? Because certainly the Crown or the government always has an interest in making things harder for criminal defendants.
Well, I think if there was a Crown colleague on this conference, they'd probably disagree with that. But
I apologize. I mean the government, not the Crown.
Yes. No, but yeah, I think that the general concern is does this open the floodgates? And I think that's a valid question, is that, do we not have to generally worry about the power of the state, and sort of that element increasingly eroding potentially accused rights? And my response to that would be that, the law is not set in stone. There are, for many reasons, including just the fact that over time, attitudes and perceptions and perspectives change, that it has to be responsive to what the community and what the society is going through at the time. And so the fact that there already are other categories outside of sexual assault, for example, alibi evidence, right? That is another area that the defense has to provide notice of. It's, again, things that will be discussed in consultation. And of course, we have our government system, which goes through vigorous debates through Parliament before anything becomes actual law. And then, of course, you have the safety of the courts, so that when the laws do infringe upon those rights, lawyers will bring those challenges.
We've got to end things there. I just want to clarify, when I refer to the government, I mean our political leaders have an interest in kind of taking tough on crime stances. I have the utmost respect for Crowns. That's all the time that we have today. Thank you both so much for joining me. We've heard today about a law of evidence for sexual assault cases and about how the accused may use records related to the complainant. The law was designed to give better protection to victims and push back against sexual assault myths. But has the law gone too far and undermined the presumption of innocence? What do you think? How do we balance these interests? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.